Welcome to the Daily Platform podcast, where we explore the intersection of law, human rights, and society. Today, we dive into a heated national conversation, the Kenya Information and Communications Amendment Bill 2025, a proposed piece of legislation that, on the surface, seeks to regulate Kenya's digital space. But critics argue it risks undermining some of the very freedoms enshrined in our Constitution. So what does this bill really mean for Kenyans? And why is it sparking such concern? Stay with me for the next 10 minutes as we break down the law, the rights, and the societal stakes.
The Information and Communications Amendment Bill 2025 has been tabled in Parliament at a time when Kenya is experiencing rapid digital growth. Over 25 million Kenyans are active online, using platforms not just for social interaction, but for civic engagement, business, and even political accountability. The bill introduces provisions requiring internet service providers, or ISPs, to collect and store detailed personal data, names, ID numbers, browsing histories, and online usage patterns. In addition, it mandates age verification for social media access using the National Identity Card System. On paper, these provisions are presented as measures to curb cybercrime, misinformation, and online exploitation. But beneath the surface, there are serious legal and human rights questions.
Let's begin with the law. The Constitution of Kenya 2010 is clear. Article 31 guarantees every person the rights to privacy, specifically the right not to have information relating to their family or private affairs unnecessarily required or revealed. Mandating ISPs to collect and retain detailed personal data opens the door to mass surveillance. This kind of blanket monitoring is not only intrusive, it risks being unconstitutional. Next, consider Article 33 on freedom of expression and Article 35 on access to information. Restricting social media access through mandatory ID verification creates a chilling effect, where people may self-censor or withdraw from online discourse out of fear of surveillance. From a legal perspective, such provisions would need to pass the test of proportionality. Is the limitation on rights justified in a democratic society? Is it necessary, reasonable, and the least restrictive means of achieving the stated goal? Critics argue the bill fails this test. The state already has cybercrime laws, data protection regulations, and mechanisms for addressing online harm. Why then a new law that so heavily tilts towards state control?
Now, let's talk about rights. The bill raises three major human rights red flags. Privacy. The bulk collection of personal data by ISPs creates risks of misuse, leaks, and even state abuse. Kenya has a troubling history where surveillance has been linked to silencing dissent. Freedom of expression. Social media is the primary platform for youth, activists, and ordinary citizens to express themselves. By tying access to national IDs, the bill risks excluding those without identification, disproportionately affecting the youth, refugees, and marginalized groups. The bill, therefore, could institutionalize digital inequality. Human rights organizations are calling for a human rights impact assessment before this bill moves forward. They argue that regulating the digital space must never come at the expense of fundamental freedoms.
Beyond the legal and rights-based arguments, this bill has profound societal consequences. For civil society and human rights defenders, the digital space is not just a convenience, it is their front line. Online campaigns, advocacy, and accountability efforts often start on Twitter, Facebook, or TikTok. Restricting access or enabling surveillance could silence critical voices. For ordinary citizens, the introduction of consumption-based billing, where internet costs rise based on usage, could widen inequality. Wealthier Kenyans may continue to thrive online, while low-income families get priced out of meaningful participation in the digital economy. For young people who make up the largest demographic in Kenya, this bill threatens to close the doors of opportunity. Many young Kenyans build livelihoods through social media, whether as influencers, digital marketers, or content creators. Requiring IDs and limiting access could choke off this emerging economy. And finally, let's not forget trust in government. A law that grants sweeping powers of digital surveillance risks eroding public trust at a time when confidence in state institutions is already fragile.
So, what is the way forward? Critics are not rejecting regulation outright. There is recognition that online spaces need safeguards against cyberbullying, misinformation, and online crime. But the process matters. Kenyans deserve transparent public consultations where citizens, civil society, tech experts, and marginalized groups can shape the law. There must also be independent oversight mechanisms to ensure that any data collected is protected and not misused. And most importantly, regulation must balance state interests with constitutional rights. A democracy thrives when rights are protected, not when they are curtailed in the name of security.
The Kenya Information and Communications Amendment Bill 2025 is not just about the internet. It is about power. Who controls the digital space? Who gets included and whose voices are silenced? As Parliament debates this bill, the stakes could not be higher. At its heart, this is a test of Kenya's constitutional promise that every citizen has the right to dignity, privacy, and freedom of expression in a democratic society. The question is, will the law safeguard those rights or erode them?
That's all for today's episode of the Platform Daily podcast. Join us next time as we continue to explore the laws shaping our lives and freedoms. Thank you for watching. If our video resonated with you, please consider liking and subscribing to stay updated. Join our community in the comments to share your insights and foster discussions that drive positive change. See you next time.